Very good evening. Thank you for joining us. I'm Faye D'Souza. We are in the discussion part of our conversation. We'll have a news bulletin up for you a little later, where at 9 o'clock, we'll just tell you what is going on. And in 10 minutes, we'll give you a wrap of all of the news, old school Doordarshan style, no opinions. We're just trying to understand what's going on in our country right now. With this conversation, I have Senior Advocate Geeta Luthra join me. Ms. Luthra, thank you so much for making time for us. And I want to thank you for being so generous with your time on the other conversations we've had in the past. For our audience, Ms. Luthra has always had a very sort of grounded, balanced opinion, which I find very comforting, especially when it comes to the law. So on a confusing case like the one that we're discussing on Disha Ravi's arrest, it's good to have that conversation right now. For our viewers who don't know, and you've been living under a rock if you don't know, the Delhi police arrested 21-year-old Disha Ravi. Now, she is a known climate change activist. Her classmates from college, her friends have all spoken up for her. She was arrested from Bangalore on Saturday, presented before a court in Delhi on Sunday, and remanded to 5 days of police custody. Now, the police have charged her with sedition, which we are quickly realizing is a favorite of the police, criminal conspiracy and promoting hatred. Now, along with Disha, there are two non-bailable warrants issued by the Delhi police for Nikita and for Shantanu. Now, according to the police, according to the press conferences of the police, Nikita, Shantanu and Disha were part of a Zoom meeting. And they apparently on that Zoom meeting planned the creation of the famed toolkit that is being talked about. And on this Zoom meeting was also Mo Dhaliwal, the founder of Poetic Justice Foundation of Canada. Now, Mo Dhaliwal, the Delhi police accuses him of being and I quote, self-confessed Khalistani supporter. Now, in a recent press conference, the Delhi police have also come out to say that among the names of the people on that document who should be followed and tagged is the name of one individual who is being linked with another individual who is a member of the ISI. This is the recent press conference that the Delhi police have had. Two disclaimers I want to give my audience before we go any further. Disha Ravi is an alum of Mount Carmel College in Bangalore, so am I. And also among the names of people to follow in the toolkit were, or to tag in the toolkit, was the Prime Minister of India, the Agriculture Minister, various members of Parliament and opposition, and journalists. One of those names was also mine. So now you have all of that information. Before we go further, let me take this question now to Ms. Luthra. Ms. Luthra, there have been questions raised about the Delhi police team, the 5-member Delhi police team who arrested Disha Ravi, not following procedure, because from what we understand, they arrived in Bangalore on Saturday, went straight to her home. They did not inform the local police of their presence. They tracked her cell phone. They arrested her and took her straight to the airport and flew out, while a couple of members of that team then went to the local police station to inform them. In your opinion, did they cut corners? Was there procedure that was not followed?
So the procedure is clearly not followed. And unfortunately, the Delhi police less so, but many state police more so. And it may sound defamatory, but the fact is that this is a common practice which we cry in the courts. But what happens is the judges are so pressed for time that they do not take action. Now it's time we start taking action in case a police of one state go to the other state. Do not record with that state that they have come, that they want to arrest the person of that state. They get it registered with the police gives them that help, and only after that can they go with the assistance of the local police. After that, if I may go on further, the next round is you have to produce the person before a magistrate, and it's known as a transit remand. So you have to produce the person before the magistrate of that state, that jurisdiction, for a transit remand. So what has been done is unfortunate, is illegal, is incorrect, and the courts have frequently ruled on that. In fact, if you remember that Bhimgaon case of Gautam Navlekar, is it Navlekar or Navekar? Same thing was said by a division bench of the Delhi High Court. It was in a habeas corpus. The fact that it was in a habeas corpus was something which Supreme Court did not approve of. But
Yes.
The fact that it was criminality, it was illegality, it was not correct, was not commented by the Supreme Court. And this was by Justice Vinod Goyal and Justice Murlidhar, who is now the Chief Justice in one of our high courts, one of our state high courts. So this judgment, in fact, and it's a fairly straightforward procedure, is laid down in the Criminal Procedure Code. It's cut and dried, but it is frequently, particularly in high-profile cases, followed in its violation by the police, and nobody does anything about it, unfortunately.
You did say, Ms. Luthra, that this is, you said, unfortunate and illegal. So are you terming, in your opinion, are you terming this an illegal arrest?
I would say it's an illegal arrest, but would I say that would the court then release on this ground? That was done in that habeas corpus judgment by the Delhi High Court, and the court said the Supreme Court did not put its stamp of approval. It didn't disapprove of the judgment, but it didn't put its stamp of approval. It said a habeas corpus would not lie when an arrest like this had been done. So in the sense that it's illegal, but what is the remedy then? The moment something is illegal, then there should be a remedy in law. But in this case, what should be the remedy is the person should be released saying this is wrongly done. And
Yes.
Procedure, when liberty of an individual is involved, when due process is required, then procedure has to be followed. This is part of our rule of law. Unfortunately, it is often followed in its breach.
And also, we understand that her lawyer of choice was not present. She argued for herself in court and broke down. Now, what is the challenge here? While the Delhi police says that the lawyer was informed, but whether the lawyer could make it on time or not, whether the lawyer was in the city at that time or not, we don't know. We do know that she broke down while she was talking to the court. There is a risk here, of course, that anything she said in this hearing is now matter of record. And she said it without the advice of her counsel of choice. Again, was there procedure that was not followed?
So we face this issue day in and day out in the courts. What happens is the police very frequently, they have to produce someone within 24 hours. That's the mandate of Section 57 of the CRPC and of 167 of the CRPC. So that's the mandate of the law. And it's the mandate of law under the Constitution of India that a person is entitled to a lawyer of their choice. Now, when we actually go, I'm talking of all cases, people wouldn't be heard. Many cases, it would not even come to light if it was not a high-profile case. So what happens is police have to produce someone within 24 hours. So you're always asking, so when are you going to produce the accused? Because you as a counsel will not be sitting in the court for 24 hours. You can't be sitting there. So you don't know when they are going to produce. So you keep calling the police station, or you keep having the one family member. If you have this whole team of people who are assisting you, be in the police station so that when the police leave with the person, and here it's a transit case, so you can't even know where they are sitting with the accused or the person they are seeking. So they can produce them any minute just before the flight and then go off. So the question is, should a person not have a right to be able to inform their lawyer and know with certainty and with time this person is going to be produced at 3 p.m. so the counsel can reach them? So the first is the right to have your counsel there, and that's part of the law of the land. There is a law against self-incriminating that gets abused because you don't have legal advice. You don't get a lawyer to assist who may have opposed the remand. So this is a very fundamental principle when you are arresting anyone. And that has been violated in this case.
There was also, Ms. Lucha, surprise of the granting of 5 days of police custody in this case. Now, we've had several conversations where you said that, that jail is the exception and bail is the norm, especially, in a case like this. And we'll come to the merits of the case in a little while. Were you surprised at the granting of the 5 days of police remand in this case?
So we are firstly, one of the aspects that this very erudite judgment of Justice Muralidhar, which I keep going back to, and Justice Vinod Goyal says that the moment you do a remand like this, which is illegal, you don't show the case diaries to the judge. Now, there used to be a purpose of case diaries because you know exactly what's the stage of the investigation of the police, what material they have against you, and what is the extent of the material so that it's not padded 2 days later or 3 days later. So you need case diaries. The magistrate can actually initial those case diaries so that we know that on the 21st or 22nd or whichever day the person's produced, this was the stage of investigation. This will be the stage. One day, every day's case diary is a must. And all this has not been done. Now, the question that you asked, 5 days remand. So on Sunday, a duty magistrate sits. After court hours, on ordinary weekdays also, a duty magistrate sits. So normally, one is very tight-fisted as a judge to give a police remand. So normally, if it's a duty magistrate, the norm is that you would say produce before the regular magistrate on the next working day. So if you produce on Sunday, you would say, since Sunday, I'm the duty magistrate, and duty magistrate actually has the same powers, but he is a little more circumspect about them. So therefore, after 24 hours, you just produce the very next day before the regular magistrate, because you know that the regular magistrate has the authority over the matter and would apply his mind fully. And a police remand has to be given. A person should have a right to oppose the police remand, in the sense that we always go and say, as defense counsels, that what is the material that is required. And the prosecution, for example, will say, we need her case diaries, we need to get her accounts, we need to get this. And the court says, but why didn't you get it 2 days earlier when you registered the FIR? all this material is not necessarily to be got from her mobile.
Forgive me, Ms. Lutra. So just to explain to our audience again, there is a difference between judicial remand and police remand. Police remand means that the accused in the case would be kept in lockup with the police, in custody of the police, in the interest of retrieving information, continuing an investigation, and in this case, likely questioning for the next 5 days.
Yes, it's custodial interrogation. And these are, in today's day, a case of what seems to have happened only in the digital world, on internet or on social media or in that context. It would be well documented, well retrievable. So apparently one account has been deleted, which was said during the remand, if I recall correctly, understand correctly. All that doesn't require the personal presence of that person. You actually require, if at all, her mobile or the details of her account or her laptop or a computer, which in any case you would have access to or you would have got into custody. You don't need the body of that person for the custodial remand, and so normally a magistrate has to be very careful, because you're talking of the liberty of a person vis-a-vis the right of the police to get to the bottom of an offense. So a court is very, very careful. It may give the same remand thrice over, but it will, so that it may give one day, then you justify another day, and the court may justify, all right, one more day or 2 more days. But a duty magistrate will normally never give a 5-day remand. He will give, in normal course, remand till the next working day, so that the judicial magistrate who seized of the matter will give full application of mind. Normally, that's the way it goes.
Ms. Lutra, we have an interesting question that's coming from one of our viewers, which is also going to be my next question. This one is from Shashidharan, who says, is talking to a Khalistani supporter legally seditious? And that brings us then to the glorious section of sedition in our country, which I think that almost every legal mind I have spoken to says sedition has no place in a democratic country. But going by what the police have told us so far, and there are 2 different statements about this particular arrest, they've accused her of 2 things. One is participating in a Zoom call in which they say Mo Dhaliwal, the co-founder of this specific outfit, that they say that he is Khalistani because he has claimed to be Khalistani in previous in previous events, and she was in this Zoom call. Secondly, they have said that she edited this document. Now, she claims to have edited only part of this document. I also want to point out that in some conversations I have had with sources in a couple of the big IT companies or the big tech companies that are involved here, they said that this was an open source Google Doc, which means anybody could go in and add their, like Wikipedia, anybody could go in and add their 2 pence, which also means it shouldn't be too difficult for the police to find out what portion she touched, because it will track those changes. Now, what part of this adds up to sedition, criminal conspiracy, and promoting hatred from that document? Do you believe that the police have a strong enough case? Now, if we break this up, if she had a Zoom conversation with an individual who is a self-proclaimed Khalistani, is that sedition? Is she to know? Is she to avoid these people? Are we all to avoid these people? Is that how it works?
No, that's not how it works. And that's not how it should work. Firstly, my freedom of speech entitles me to talk to whoever I may choose to talk to. The content of my speech for sedition, I first want to talk about sedition.
Please.
Sedition was brought in by the British and remained on the statute book because the British brought it they were wise enough to remove it in their country, but wisdom has yet to dawn upon us. The Law Commission, I think Justice B.S. Chauhan was the chairman of the Law Commission when a paper was written in which it was suggested that this article, this section be deleted from the Indian Penal Code. It's outdated, it serves no purpose, it only helps the government in power. And the government in power is not what is supposed to be helping. Kedarnath, which was decided in 1962, and Vinayak Sen's case, which everybody would be conversant with, which was the Chhattisgarh doctor, where some pamphlets were discovered, and he was charged with sedition, with conspiracy, and finally Supreme Court ruled on it, are cases where the Supreme Court has repeatedly said that disaffection or disagreement with a government in power is not a disagreement or disaffection for the country or the state. And somehow, despite this interpretation, the language of the section, because it was for the British time government, which was different from the people it was ruling, the language used could be justified. Today, it can't be justified. And today, the Supreme Court has already said in Kedarnath as well as in several cases. And it's not just the central government. It's used by any and every state government all the time, whatever party, whatever dispensation. So that's the reason why it has been repeatedly a plea by jurists, by those who believe in civil liberties, that sedition does not have a place in our statute. And it infringes the fundamental right to freedom of speech and expression. Now, if I'm not mistaken, it's punishable with 3 years.
Yes.
The Supreme Court during the COVID times, and I don't think that circular has been changed so far, has been saying that those accused of offenses below 7 years should, as far as possible, be looked at by each state, whether they should be arrested and jails be filled up, or custodial arrest be filled up when these offenses are not of such a serious nature. Now, coming to the facts of this case and her Zoom call. To my mind, the Zoom call could not attribute any element of sedition. Firstly, you have to give the contents of that call. What in that call was seditious? My association, even with a murderer, for example, if I may talk to them, would not make me a murderer. So my association with somebody who has disaffection for the country does not create me to be a person who has disaffection for the country. So this is the first aspect which I feel a Zoom call is no indication. Second, the fact that somebody may in some other sphere have affiliation or inclination, which in the context in which her conversation seems to have been, or her contribution seems to have been, is not in the context of 124A and cannot attract 124A. So I have my fear with this is, as in all cases where freedom of speech and expression is repressed on the ground of sedition or disaffection among communities, is we have to look at it closely. That is it a cloak to curb speech? And that I feel in this particular case, there is no material whatsoever. Now, with regard to the Google aspect of the fact that it's a Google document, I would agree with this completely. And if you look at the contents, what they are saying is just have a Twitter strike or whatever. So a social media strike where you are flooding social media with one particular viewpoint will not definitely create disaffection. And in this, I may have quoted this on your channel before, so I will apologize if I have. But my favorite political philosopher was John Stuart Mill. And he said that freedom gets stronger, opinion gets more open if we have, like a prism, several viewpoints, and each viewpoint will only bring out the best in us, so that 99 people may agree to one viewpoint. The one with the 1% viewpoint may ultimately become the majority view after several years, just the same as Justice H.R. Khanna's dissenting judgment. So this, we become stronger with difference of opinion. And I'm sure, and I see it every day, that there are two strong viewpoints on this issue, and both have their right to air their views, but that doesn't make one right or wrong.
Ms. Luthra, I'm reading right now the report that has come in about the police press conference. Now, the police says that, and I'm just reading out of this, that basically Disha Ravi, who was arrested, they apparently have collected phones and laptops from her home, from which they are gaining information. That they've said that the toolkit was effectively, it led to the Republic Day violence that left 500 police injured on that particular day. And it was Nikita, Shantanu, and Disha and others who collaborated towards the draft of that toolkit. Based on information gathered from Nikita and her device, several teams were sent to Beat District. They're looking for the other two people. They're also looking at one, Peter Friedrich, who was named in this document as someone to tag or someone to follow. We understand from the police that Friedrich has been on the radar of the Indian security establishment since 2006. He was noticed in the company of Iqbal Chaudhry, who is a proponent of ISI. And the police find that this is a particular link that they want to right now investigate. Is it necessary for them to keep Disha in police custody for the next 5 days in order to investigate this angle as well?
So, as I said earlier, that if they wanted her laptop, if they wanted her, all her instruments, this was available to them on Saturday. That doesn't even call for 1 day's remand, to my mind. Insofar as what they want, the angle that they want to investigate, I'm sorry, it does not require a police remand. Now, insofar as the aspect of digital strike is concerned, which was suggested to be done from January 23rd, I do not see a single word that suggests violence that suggests anything but a peaceful protest. I have not been able to discern, nor what the police say, show a single word, a whisper of being violent, aggressive, or disaffection. Just ultimately, what did Mahatma Gandhi say? He said, have peaceful protests. Ultimately, we are the nation that believes in it. So we, as what may have happened on 26 Jan was unfortunate. I
Yes.
think everybody acknowledges it was unfortunate and not at all necessary. But to attribute it to innocent people who are just trying to channel protest in a peaceful manner would not be correct to my
There was also a statement in that document that said, and I'm not quoting verbatim because I don't have it before me verbatim, but it basically said that India is known for the country as a country of yoga and chai, and we need to disrupt that view of India to show the world what is really happening on the ground. Can this be viewed as seditious, anti-national, and disruptive for the country?
No, I don't think so at all. India is known as the country of yoga and chai, but I don't agree with the authors. But that may be my view. India is also known as the country which believed very strongly in peaceful protests, which is how we got our independence. And India has always valued freedom of speech and expression. And I hope we will continue to do that. We should not be seen as a country that is quelling protests. I may agree, I may disagree with the farmers, that's a different view. But we cannot be seen as a country that does not appreciate an opposition or a point of view that is different from one's own.
My last question to you, Ms. Luthra, is the fact that there is, of course, a lot of focus on the fact that Disha Ravi is 21 years old. She's a young woman straight out of college. She was a good member of society, always responsible, took part in a lot of cleanups and drives that were environment friendly. But that really doesn't really have weightage in this argument, because at the end of the day, the law views you as a legal entity at the age of 18. You take responsibility, you can vote, you can drive, you can
you can marry
whoever you choose. You hopefully marry whoever you choose. And so you're held accountable for your actions. Should the argument here be refocused on the legality of the case, which you have just broken down piece for piece, as something that doesn't hold water at all?
So, see, India is a very empathetic country. And so we empathize with age, with old age. And in a sense, I appreciate that. But we cannot take away the argument. The logical argument is one of reason, which once a person is 18, we have to assume they are responsible for their acts. The fact that she didn't really do any illegality in the eyes of people should not be, or according to me, in law, should not be minimized by her age. We have to look at the fact of what is the legality or illegality, or the rightness or wrongness of the acts of the police, and how the state can redress so that we don't repeat these errors again and again. And this happens again and again in many cases. And the moment that it's a person or the police become over anxious, they throw the laws to the wind. That they cannot do, because that's the only thing that protects a citizen. And that's why it's so important that both the letter and spirit of law is respected, and the courts come down heavily if there is an infraction.
Vishal, Kamala Kanan asks, if the police are found to be at fault, can we expect police involved to face any consequences?
So there are cases and cases where I've known even magistrates to summon the police and take action. I've known them to get disciplinary direct that the commissioner will look and do proceedings of within a departmental inquiry. I've known courts to come down heavily. There are judgments where courts have criticized, and that has affected service records of those who have committed infractions. Should this be done? According to me, it should. See, if in some cases an illegality goes unpunished, then people become emboldened. If it is punished and taken to its natural course, then 10 more people will be warned from doing it. So according to me, it should take its natural consequence, both at the level of the highest level as well as in the courts, so that such illegality is not repeated in future.
Right, Ms. Geeta Luthra, thank you so much for spending time with us and answering all of those questions. And I appreciate the patience with which you dealt with all those questions. I look forward to speaking with you again very soon.
Thank you.
Thank you. For our audience, we'll have your bulletin up very shortly. But just to put it in a nutshell, the conversation with Ms. Luthra, she said that the Delhi police did, in fact, break the procedure of what should have been done when they arrested Disha Ravi from Bangalore. First of all, they should have informed the local police. They should have presented her to a magistrate in Bangalore to get the transit remand, which they didn't do, which means the arrest per se would be illegal and she ought to be released immediately. Secondly, presenting her on a Sunday with her lawyer of choice not present, not having legal counsel is basically mischievous, to just get away with it, and to present her to a duty magistrate and get 5 days remand. All of these things are worrying. It's not so much her age or her gender that should be focused here, but the procedure or the lack of it in this case that should be the point of conversation. Also, all of the things that the Delhi police have told us in their press conferences so far suggest that this investigation could easily have been conducted or completed with the help of the devices that they seized from her home on Saturday. There's actually no need for them to question her in custody for 5 straight days, and that's something that should be brought into question again. In the meantime, the Delhi police, from their latest piece of information, are looking for the other 2 people that they have now issued non-bailable warrants against, Nikita and Shantanu. We'll bring you updates on that as soon as we have it. Remember, the idea here at the end of it, while this tends to be an emotional thing, is to focus on what our law tells us. And we have a very strong penal code and a constitution that gives rights to every single citizen. Fundamentally, whether police or government or citizen, we have to refer back to the law. And that's where it ends. So thank you again for being part of this conversation, and stay with us for more explainers and news bulletins and updates.